Hi everyone, good afternoon. My name is Chris. This is my colleague Nia. We are partners from Christopher and Lee Ong. So today we are pleased to be invited to share a bit about FIDIC Silver Book 2017. Just before, at the very beginning, can I have hands on how many of you actually uses FIDIC in your projects? Is it oh, that's very little. Is it Silver Book? Which book do you use?
Yeah,
Silver Book.
Use red, silver.
Red and silver.
We have different type of products.
Okay.
Silver
Okay.
as well.
Okay. Understand. So before we start, just a bit about our law firm. So we are currently the biggest or the second biggest in Malaysia. We have about 120 lawyers in our firm. So we are basically a full service law firm. So we do everything from if it's projects related, we do everything from the very beginning, from the inception of the projects financing, all the way to disputes. So so we are part of this network called Raja and Tan Asia. So currently we have offices in 10 countries. So that includes Malaysia, of course, then Singapore, Cambodia, China, Indonesia, Laos, Myanmar, Philippines, Thailand, and Vietnam. So of all the officers, we have about more than 1,000 lawyers. So that's a bit about the firm. So he basically focuses on disputes. So he does a wide range of disputes, which includes construction disputes as well. So for me, I'm mainly doing the front end part. So I have a bit of dispute experience previously, but currently I'm focusing on the front end part. So I do contract drafting, contract negotiating. So I'm familiar with all these standard form contracts as well as the bespoke ones. So a bit of introduction if any of you is not so familiar with the FIDIC contracts. So basically FIDIC is the International Federation of Consulting Engineers. So they are best known actually for their publications of all these standard form contracts, various colors that we know. So these contracts are usually used for international construction and engineering projects. So usually these forms of contract actually used throughout the world, and actually usually if it involves international parties. So in the context of Malaysia, in the Malaysia projects that we see using FIDIC, usually one of the parties is an international party. So if both are local parties, they are actually not so familiar with FIDIC, they might go for other form of contracts. So in the Malaysia context, FIDIC, recent years they are gaining popularities because there are more and more international players in Malaysia projects. There are also some other standard form contracts that we usually see being used in the Malaysia context. So in Malaysia, there is the PAM form. PAM is the Institute of Architects Malaysia, and also the JKR form. JKR is the Public Jabatan Kerja Raya, Public Works Department of Malaysia, PWD. So those are the forms that are more familiar by the local players, and they usually adopt that in their construction projects. So we go into what kind of standard form contracts are there in FIDIC. So FIDIC published a lot actually, I think around 10. The most famous ones are usually called the Rainbow Suite. So they are the Red Book, Yellow Book, and Silver Book. So the Red Book, usually it's for building and engineering works designed by the employer. So the employer undertakes the design responsibilities, and the contractor is basically just building in accordance with the design provided by the employer. So the employer either designs it himself or they engages another consultant to do it. And there is an option for a bit of design responsibilities on the contractor, but it is usually very limited. So this is mainly for designs by the employers. So for Yellow Book, it's usually for M&E, building engineering works as well, and it is mainly designed by the contractor. So you have the engineer administering the contract similar to the yellow book, similar to the red book. So the silver book is a bit different. The silver book is for EPC or turnkey projects. So what that means is that basically under silver book, the contractor will undertake most of the responsibilities. So, the employer has quite limited responsibilities under the agreement, usually just to provide access to the sites and to make payments and to have certain permits. So, and a special feature about Silverbook is that there's no engineer. So there's no requirement of engineer administering the contract. The contract is actually administered by the employer themselves or through an appointment of the employer's representative. So later we'll come to that. That's a bit different because usually they are seen as a more neutral party, but when it is employer's representative, what's the consequence of that? Whether they are actually impartial because they actually have to determine or decide certain claims under the contract. So these are some of the less common FIDIC contracts that we see being used. The Gold Book is for design, build, and operate projects. Then the Turquoise Book, dredging and reclamation works. Green Book, short form of contract, and White Book is a model services agreement. So a bit of history about these FIDIC contracts. It dates back to actually 1995. So the first was actually the Orange Book. Then 1999 versions are the most known versions because in 1999, the Red, Yellow, and Silver Book were published. So these are actually then after 2005, there are more versions. Then 2017 is the second edition of what I say is the Rainbow Suite, the Red, Yellow, and Silver Books. Then 2022, there are some amendments to 2017 versions. So the thing is, although the second version of all these yellow, red, silver books have been published in 2017, but what we see now is that most of the projects that adopt FIDIC, they actually still prefer 1999 version. Part of the reason is because some of these contractors or employers have been using these FIDIC contracts for many years, so they are comfortable with the terms in there. They are familiar with the risk allocation obligations in there. So a lot of them stick to the 1999 version. But actually 2017 version, although it is much more elaborated, actually a lot of the provisions are actually elaborated further. So for example, the Silver Book 2017 is actually much thicker than the 1999 version of the Silver Book. But you have to see the introductory notes provided by the FIDIC. So FIDIC is actually saying that even though there are significant changes to the provisions in the FIDIC contracts, the main thing, which is the risk allocation, actually stays the same throughout the three types of the agreements. So then the changes introduced in the 2017 Rainbow Suite are actually substantially similar across the red, yellow, and silver books. Of course, today we are focusing on silver books, but some of the points are similarly applicable to the red and yellow books. So, and the last point is my favorite actually. So the definitions are actually now in alphabetical order. So one thing about this 1999 silver book is that you know how the definition sections of a contract is usually in alphabetical order, but one strange thing about this 1999 silver book is that it is actually not in alphabetical order. So it is actually grouped in accordance to the nature of the definition. So if the definition relates to payments, it's actually under one clause. Then if the definition relates to the parties, then it's actually in another clause. And these clauses don't even arrange them alphabetically. So sometimes if you are referring back, it's a bit hard for you to actually find the definitions that you want. But now it's no longer an issue. So I will talk a bit about which form to use. The characteristics of the characteristics of this book. So just like I mentioned Green Book. So Green Book is usually for a relatively easy task. So it's for a small contract, simple or repetitive works. So, and it doesn't really matter whether the design is provided by the employer or the contractor, because it is a very small contract, so it is very short actually. So it's for a very straightforward works. So then we have the Red Book. Like I say, the employer does nearly all the designs. Then the engineer will administer the contract and monitors the construction works and certifies payment. Then the employer is there. Of course, they are kept fully informed because they're the employer, they're the project owner, and they can make variations, etc. And the contractors are actually generally paid on a measurement basis. So there'll be a bill of quantities, there'll be bill of quantities, and then there'll be measurements towards the end of the projects. Then, or I mean, if you want, you can pay on a lump sum basis as well. But usually Red Book is on measurement basis. Then we have Yellow Book. So Yellow Book is generally, to be honest, it's more commonly seen because it's generally applicable to all types of construction works, and where the design is actually carried out by the contractor. So you see in electrical mechanical plants, the design executing of building and engineering works. And usually payment under Yellow Book is according to achieved milestones and is generally on a lump sum basis. Then we come to Silver Book. So these Silver Books are actually usually used in turnkey projects. What we mean by turnkey is basically contractor does all the works, give the owner the key towards the end, and the owner turns the key and they can run the whatever buildings or plants that they contract the contractor to do. So we see it more on the power plants and private infrastructure projects. It is suitable only for very experienced contractors because the contractor is actually taking a lot of risk under the project. So, and this is usually huge projects. So the risks are a lot and very complex. So it takes a very experienced contractor to actually do it and also to properly price for it. So then of course, because the contractor is doing most of the works, carrying out most of the responsibilities, so in a certain way, it gives the contractor certain flexibility in how they carry out the works, as long as they comply with the contract. So let's say if there's only one completion date, so within the period of the contract, it sort of doesn't really matter how the contractor does it, as long as they complete it by the completion date. Of course, then you have to see whether there will be sectional completions and whatnot. But yeah, but those are the side issues. But it does give the contractor more flexibilities in terms of what to do. Then we go into some of the common issues and what FIDIC provides as solutions under the contract. So of course, the biggest issue is always delay in project completion. So always there'll be delay due to unforeseen circumstances, inefficiency of contractor, variations by the employer, or even any acts of preventions by the employers. So you know, the solutions, I'm talking about some of the available clauses under FIDIC. So there are clauses in relation to the submission of the program, the revision of the program, extension of time, and delay damages. So then there are also variations and changes in scope, payment delays and disputes, and you know, issues in relation to quality of the works. You know, whether there are defects in the works requiring remedial works. Then of course there are also force majeure and unforeseen risks. So natural disasters, pandemic, all this. Who is going to bear the responsibilities, you know, for the delay or the cost? Then there are dispute resolution and claims. So there are always contractual disputes, you know, rising from the interpretation or misinterpretation of the contractual clauses, delays or financial disagreements, payments. Then there's also issues relating to health, safety, and environmental compliance. So these are actually all sort of covered under the FIDIC. Of course, some provisions are more comprehensive than the others, and there are always ways to amend the FIDIC contracts if you require. So now we come to the Silver Book, which is the focus of today's session. So an overview of the Silver Book, like I said, it is actually intended for EPC or turnkey projects where the contractor actually accepts the maximum risk. Of course, you can redo the risk allocation by using special provisions, basically amending the general conditions of the FIDIC, but that, from my perspective, that actually defeats the purpose of using the Silver Book. So when you are using Silver Book, you are actually expecting the contractor to accept most of the risk under the projects, and usually it's a lump sum contract. So there is actually a fixed price certainty, and there is a performance-based delivery. But of course, there'll be some provisions for the adjustments of the price, and there'll be some provisions relating to all these performance guarantees, which I'll come to it later. So it's actually a hands-off approach. So employer doesn't really intervene that much after they have awarded projects, apart from being informed of the progress of the projects, certifying payments and all those. They actually don't do so much in terms of the project's execution. So then the lump sum I mentioned, there's a fixed date for completion, and then limited ability for the contractor to claim an extension of time. Of course, this one you have to take into account whether the contract provides for sectional completions, because if there are sectional completion, meaning that there are certain sections that you have to complete earlier than this final completion date, then of course you have to take that into account, because you have to see what are the dates for all these sectional completions and plan your project accordingly, so that you don't actually incur delay damages for all those sectional completion. Then there's single point of responsibility. The contractor responsible for proving performance and reliability of the completed facilities. So the contractor will do the testing and commissioning, and they have to prove to the employer that whatever that I have built is within the specifications and the performance guarantees that I provide under the contract. So the focus is actually on long-term performance and the ability to generate revenue. So a bit about the structure of the contract itself. So a very substantial part of the FIDIC contracts are actually the general conditions. So the general conditions is what we call the standard form. So those are the ready, contractual provisions that are actually provided by the FIDIC. So then there are actually particular conditions. So now they are called particular conditions Part A. Part A is the contract data. So the contract data is usually the numbers. So for example, you mentioned about completion date in the contract. You have to fill up the actual dates or the period in the contract data. And that's very important because some parts of the FIDIC, they actually provide that, for example, the amount will be provided in the contract data. Some of the provisions say if you don't provide for it, there's a default. So for example, cost plus profits in the FIDIC, it actually allows you to put in the percentage of the profits in the contract data, but it says that if none is provided in the contract data, by default is 5%. But there are some provisions where if you don't put in any amount in the contract data, the whole provision is actually not applicable. For example, performance bond. If you don't state any amount in the contract data, the FIDIC general conditions actually says that then the whole provisions of performance security is actually not applicable, meaning that you don't actually have to provide a performance bond under the contract. So You have to be very careful when you are filling in the contract data. Then there is particular conditions part B, which we call special provisions. So special provisions are where we actually amend the terms of the general conditions. So for example, in FIDIC, it provides, for example, 28 days for you to provide notice. It is up to you to amend it to 48 days, 14 days, but you cannot amend it directly on the general conditions itself. You have to do it through these special provisions. So it's basically a document attached to the general conditions, and it will say that, clause whichever is amended this way. So this has to be read together with the general conditions.
Pertaining to the both conditions, GCC and PCC, we can have the amendments of particular condition of contract during the contract. We cannot have the amendments in the GCC.
Can we have the amendment of contract as per the GCC clauses, or we can only have the contract amendments under the particular conditions of contract?
So the thing about all these standard form contracts is that we don't do the amendments to whatever that's readily provided. So although we amend the general conditions, for example, but we do it through the special conditions. So in the special conditions, we actually list out item by item. So let's say clause 20.1 is amended this way, or you just delete the whole clause, or you replace the whole clause. But you do it through the special provision. So for example, if you buy the contract from FIDIC, it actually doesn't allow you to make amendments to the general conditions. So you can't actually do it. And of course, if you do it directly on the version, it is actually going to be messy. And if you do the amendments directly in the contract itself, it is as if you're actually doing a bespoke contract yourself. So a direct amendment to the contract is actually what we usually do to bespoke contracts. But for all these standard form contracts, it's usually done by way of attachments. So it's important to keep in mind that you have to read it together. So actually in a lot of projects that we see, because the project's negotiation is usually done by another team, and the project's execution is actually done by a different team. So sometimes there's a miscommunication. Sometimes the project execution team actually only reads the general conditions itself. They think, okay, so these are the procedures, these are the things that we have to comply with, not knowing that certain provisions might have been amended by the special provisions. So when you are reading it, you have to, it's a bit inconvenient because you have to flip back and forth, but you have to be very careful what terms have been amended. And another point about the amendment is also that you have to be careful and you have to know what are the consequential amendments. So you don't want the fact that you amend one provision and it actually causes inconsistencies or some ambiguity to other related provisions in the contract. So and when you add in additional provisions, for example, if you add in some personal data protection policy or certain company policies that you want the parties to adhere to, then of course there are other related provisions that you might want to amend. For example, what are the consequences of the breaches, the termination provisions, what are the consequences of termination because of the breach of these policies. So basically you have to think holistically of what to amend and not just focus on that particular provision that you are amending. So that's important. So that's why I put in red here saying that everyone has to be aware that whatever you put in the special provision, it overrides the general conditions. So even if sometimes some people don't specifically amend a certain clause in the general condition. So for example, in the general conditions, it actually talks about how claims should be made, and you provide a separate procedure which is entirely separate in your special provisions, without mentioning that original procedure in your general conditions, the effect might be that the whole provisions of claims in the general conditions might not work because then the special provisions would override. So how usually arbitral tribunals or the courts interpret it is that because this FIDIC, the general conditions are whatever that is readily drafted for you, and in the special provisions is whatever that is specifically drafted by the parties. So actually, the special provisions represent the intention of the parties. So if you put it in the special provisions, the consequence is that it will prevail over the general conditions. That's why when you're amending the contract, you have to be extra careful of that. So these are some of the key features. So I talk about the contractor's responsibilities. I mentioned fit for the purpose here. I'll talk a bit more about that later because the 2017 version of the Silver Book actually it contains a more elaborated, a more defined provision on fit for purpose. Then it provides certainty in cost and time. So like I said, lump sum price, a fixed completion date, and the employer usually likes that because it provides certainty, and there are very limited circumstances where you can claim for costs or extension of time. So like I said, this is for turnkey projects. Then there's minimal employer involvement. And for unforeseen circumstances and unforeseen conditions, generally, the adjustments allowed under the contract is very limited. Of course, there are some of the provisions allowing for adjustments, which I will come to them later. So some of the key changes in the contract administration under the 2017 version. So firstly, the 2017 version actually makes it more prescriptive. So as I mentioned, they are actually the provisions under 2017 Silver Book they are actually a lot more elaborated. So they are more prescriptive. They actually tell you clearly what to do, what are the process, what are the procedures. Is that really a good thing? I mean, it depends on how familiar you are with the procedures and what is your compliance status. So if you are very familiar with all the different timelines under the agreement and you comply with them, then of course that's good for you because the process is clear. But again, on the flip side, it leaves little to no room for you to not comply with it. So so it's actually they are both sides to it. Then there are step-by-step project management procedural mechanisms. Again, it provides certainty, but is it really a good thing? Really, you have to be very familiar because I mean, I can actually give an indication here. So this is what I printed out. This is a 1999 version of the Silver Book. So and this is the 2017 version. So it's almost twice the thickness. So that's so a lot of things that are in it doesn't change the essence of the provisions because, like I said just now, the risk allocation under the agreements are actually still the same. But of course, when it's more elaborated, that means that there are more things for you to comply with before you actually can claim certain things. And then also it sets out the expectations from the parties and importantly from the employer's representative. I'll come to that a bit later. So just now I mentioned about employer's representative. So I say that there's no engineer under the Silver Book, which is actually very different from the Red and Yellow Book, because Red and Yellow Book, engineer is basically it's clear that engineer is sort of like a third party, although it is usually is usually engaged by the employer. It is sort of like a third party. They are, although under certain circumstances, they are actually giving you instructions on behalf of the employer and whatnot. But most of the time, it is treated as a neutral third party administering the contract. But Silverbook is very different because the administration role is actually done by the employer himself or by the employer's representative. And most importantly, under the Silverbook, the employer's representative is actually the one that will agree or determine the claims by the parties. So they are, previously it wasn't made so clear, what are the role of all these employers' representatives in their capacity, especially when they are determining and agreeing the claims. What happened? Will they actually favor the employer because they are the employer's representative? It's not very clear under the 1999 version. So in 2017 version, they actually enhanced the employer's representative's role and jurisdiction. So most of the claims actually have to go through the employer's representative first. So you have to actually go through the process first before you can actually go for dispute resolution. So there are a lot more to be done by the employer's representative under the 2017 version. So there are some additional provisions which are intended to actually, protect the credibility of this employer's representative. So it's actually expressly provided that, employer's representative shall not be deemed to act for the employer when they are agreeing or determining a claim or other matters, and they are actually contractually obliged to reach a fair determination within the prescribed period. So these are their contractual obligations. Then, of course, there are also certain time limit for them to actually deal with the claims. I will talk about the time bar later. And the employer's representative, they are not allowed to delegate their authority to agree or determine claims. So they have to do it themselves. Because under the contract, there are certain things that they can actually delegate. So they are like the manager, and they can delegate tasks to their subordinates, but this agreeing and determining claim is not one of them, so they have to do it themselves.
The difference between the engineer and the employer representative. Most play in the same mode. Sorry. So about the difference between the engineer and the employer representative. Both in the project play the same role. So what is the difference here?
So as I mentioned just now, the role of engineer and basically engineer's role in the contract administration is actually a bit clearer because in red and silver book, for example, because red and yellow book, for example, because it is clear that an engineer has to be, actually appointed to administer the contract. So and there are some provisions surrounding on how engineers should administer the contract. That's one. For employers' representative, one thing about Silverbook, like I say, is that there might not be any employers' representative actually, because it can be administered by the employer themselves. Second thing is that employers' representative, actually, when they are doing most of the things under the contract, they are actually representing the employer. So for most things, for example, issuing instructions, giving certain instructions relating to the project execution, they are actually doing it on behalf of the employers because they are the employer's representative. There is another contractor's representative under the contract. But in determining the claims, they should assume the role of sort of a neutral third party. I mean, that is the ideal situation under the contract. That is what is provided under the contract. But an issue is always, the impartiality of these employers' representative, where they are actually agreeing or determining the claims, because at the end of the day, they are the employers. They are the employee of the employer. They might not want to do something that would actually jeopardize their employment. So there's actually, I can see that in practical there will be issues of determining the claims, and a lot of all these claims would actually end up going for dispute resolution because for example, if I am the employer's representative, I look at the claims of the contractor, I reject the claim. What would the contractor think? Would the contractor think that, okay, the employer's representative is actually doing a fair determination of my claim? Or they would think that, oh, actually, because they're working for the employer, so they just reject my claim. So, so there are a lot of, for me, in practical, these provisions don't necessarily provide, the full kind of protection that contractors might prefer. So yeah, I mean some people, they actually amend the provisions of the Silver Book to appoint an engineer, but again, usually if you use Silver Books, you know that they will not be engineers. So yeah, it depends on whether you actually want a third party to administer your contract. So you can amend the contract accordingly based on what you intend to do. But again, the default position under the Silver Book is that everything will be done by the employer's representative.
Excuse me.
Yeah.
Item number 2 and item number 3 seems contract. I don't quite get it.
Number 2 and number 3.
Yeah. The item number 2. Number 2 actually mention employer's representative will agree or determine the claim by parties, whichever. I don't understand the parties who they are referring to. Item number 3 claim that the employer's representative shall not be deemed to act for the employer when agreeing or determining a claim or other matters. So can you explain? It seems like very contradictory, but I don't understand what is the relation between these two.
Okay, so point number 2 is actually talking about the powers of the employer's representative. So under the FIDIC Silver Book, the employer's representative is actually empowered to agree or determine the claims. So when I say parties, is employer and contractor. So when there's a claim by an employer or there's a claim by a contractor, so there is a process. Later I'll explain in more details, but just briefly. So there is a process for the employer representative to actually go to both parties to see whether they can come to an agreement in relation to the claim. So if they can't come to an agreement, then there is a process for the employer's representative to actually determine the claim. So for example, today the contractor submits a claim for 12 days EOT. So I am the employer's representative. There is actually a process for me to, within a certain number of days, I have to go to the employer and the contractor to try to see if they can agree to, the claim. Let's say they agree to 10 days, then I will actually issue a notice saying that these are the agreements by the parties. The completion date is extended by 10 days. But if there's no agreement, I have to proceed to actually look through the claims and actually determine whether the contractor is entitled to any EOT, and if so, how many days. So that again, there is a process. So I determine 8 days. Then I'll issue a notice saying that this is my determination, 8 days of EOT. So there is the employer's representative role under the contract itself. Number 3 is related to that, because when the employer's representative is actually exercising their power to determine the claim, they have to act impartially. They are not acting for the employer. They are regarded as a neutral third party. So you see, it's a bit confusing because the name of employer's representative means that I'm representing the employer. But what the contract provides is that when I am using my power to determine the claims, I'm actually not acting for the employer. I'm basically acting for myself. I'm a neutral third party determining the claims.
Actually, he is representing the employer to reserve and owe you the work as per the requirement for the employer. Because in the Silver Book,
Yes.
we just provide the requirement. We need this.
Yes.
We need this kind of project, and representative of the employer AER, basically we call him AER. AER is
Determined to do the evaluation, either the work is going as per the requirement of the client or not. So he's just doing that, and if there is conflict between both, then he will determine the claim or he will determine the dispute to rise up. Right?
Yes. So in 1990, like I mentioned, in 1999 version of the Silver Book, this is actually not made clear. So it's actually not made clear when which capacity is actually this employer's representative is acting for. So under the 2017, in the contractual provision, is clear. When I am determining the claims, I'm not acting for the employer. So to be seen to be impartial. But like I say, in practical, how is it going to be exercised? We don't know because we can't crack open the employee's representative head to see what they're thinking. So they might still favor the employer for known reasons because they are employed by the employer. So again, the practicality. I mean, of course, I would say the intention of these added provisions are good because it is supposed to add, certain protection to the contractor and also to add credibility to the determination by the employer's representative. But at the end of the day, the value of these provisions might be diminished by how the claims are actually agreed or determined in real life by the employer's representative. So I'm not sure whether these provisions, because the intention of these provisions are actually to help reduce the disputes between the employer and the contractor. So they are more credible decision by the employer's representative. Then the employer or the contractor would not go for dispute resolution afterwards, go for the dispute avoidance board or like adjudication or the arbitration. But would it work in real life? I'm not so sure because at the end of the day,
Who is the paymaster for this employer? If it's from an employer, then definitely he has a certificate.
I mean, yes, they are being paid by the employer. So a different thing of them with the engineer or like architect. Sometimes in some other contracts we see the architect as the contract administrator, is that these employers representative, they are real employee usually. So they appoint someone from, let's say, their company or a related company to actually administer the contract. So engineers and architects, they are usually also engaged by employers because they are engaged through all these consultancy services agreements and whatnot. But a different thing is, at least in the context of Malaysia, engineers and architects, they are actually regulated. So there are Architects Act, there are Registration of Engineers Act, and there are actually codes of conduct of all these architects and engineers. So there are certain, statutory or legal duties that all these architects and engineers are subject to. So in a way, it can be more certain that there are more protections and there are more assurance that these engineers or architects, these professionals, they will actually act impartially in actually administering the contract, especially in determining claims and all this. For employees representative, I can say that I'm not so sure in practice because, like I said, at the end of the day, they are employed by the employer.
It is in practice. We have a project we have just completed 2 years back. And in that project, we have been dealing with the employer representative. Definitely, the assistant to employer, or we call as employer representative, they are hired to protect the needs of employer, right? So what if, like you said, the employer representative must not be the partial, right? So if he does the same, if he do the partiality, if it shows the partiality towards the client, so this is why the disputes rises, and we go to the next procedure of the FIDIC for the dispute adjudication courts. Yeah. So this is another provision to protect the interest of contractor as well. If the employer representative is partial, so the dispute rises. You both parties are not agree on one thing, the dispute rises, so you go for the dispute adjudication board, right?
Yes. Yes, agree. So and one important thing to note of this 2017 version of FIDIC is also that most claims, before you can actually go for dispute resolution, you have to go through the employer's representative first. So you have to go through this process of determining the claim first before you can actually go for dispute resolution. So this is something that you have to keep in mind. So the like you say the partiality or impartiality of the employer's representative, is actually quite important, because if the employee's representative is actually seen as partial unfair, so favoring the employer a lot, then what you can imagine is that there will be a lot of disputes arising out of it. So this process of determining the claim is basically rendered just academic. So a lot of times you would just go through this process in order to get to the dispute resolution part, because this process will be rendered meaningless if the employer's representative cannot act impartially. So again, the new contractual provisions are intended to show impartiality in the employer's representative, but hopefully it works in real life. So like I say a bit, so this is just briefly about dispute. So like I mentioned just now, dispute is actually now a defined term in the FIDIC contract. Previously it wasn't really defined, so dispute is just the general sense of dispute. So now dispute, you see the first point. So a dispute would only arise where one party has actually made a claim and actually go through this so clause 3.5 is where you have to go through this process of agreeing or determining the claim by the employer's representative. So you have to go through this process before a dispute can arise and before you can actually go for the dispute resolution process. So then the second point relates to the first one. So there have to be a rejection of the whole or part of the claim. And then there is a requirement to give a notice of dissatisfaction. So we'll come to that a bit later. So now we go to the common issue. Okay, so these are actually the common issues in FIDIC contracts, and to be honest, these are common issues in most of the projects worldwide. So firstly, it's on claims and variations. Secondly, risk allocation. So what are the obligations divided in between the employer and contractor under the contract? Thirdly, the payment mechanism. Is it milestone payments, interim payments, monthly payments? And the delay in payments. And of course, last but not least, the dispute resolution and avoidance. So we go into the first issue first. So claims and variations. So we talk about variation first. So under the FIDIC contract, this is quite usual. How you initiate variation, you can just give the employer can just give a direct instruction directly, or they actually request for a proposal from the contractor first. So so for example, request for proposal, I tell you, what I intend to vary, you give me a proposal, then I evaluate the proposal and I see whether I actually want to proceed. So if I want to proceed, I go back to actually the first one. So I give you an instruction to proceed. Then afterwards, it will be the same process. So the 2017 version, the process is actually much more elaborated now, but largely the process remains the same. A new thing about this 2017 FIDIC Silver Book is actually on grounds where the contractor can actually object to a variation. So so initially under the 1999 version of the Silver Book, it says that the contractor can actually reject a variation if, firstly, the contractor cannot readily obtain the goods that are required for the variation works. That's one ground. Secondly, the variation works will actually reduce the safety or suitability of the works. And the third ground was that the variation works will actually have adverse impact on the achievement of the performance guarantees.
I would like to ask one thing.
Yeah.
We are dealing with the silver book, no?
Yes.
In silver book, in EPC contracts, the client only prepares the preliminary design. The detailed design and the BOQ will be prepared by the contractor, EPC contractor. Once it is prepared, the quantities cannot be changed because a contractor has to just provide just has to follow the requirement of the client.
Yeah.
If the BOQ is getting changed, the variations can be asked. The quantities are changed. So I don't know how under the silver book, a contractor can ask for the variations. If the requirements has been changed by the employer, then he may ask.
Yeah.
But if the requirements are not changed, how he can ask for the variations?
No, so this are you talking about the grounds that I mentioned? So just to clarify, the variation under the FIDIC Silver Book is actually, it will be initiated by the employer. So yeah, so like I mentioned, two ways. One is by a direct instructions. Secondly, I request the contractor to give a proposal first. So then the employer will evaluate the variation proposal and determine whether
Only then when the scope of work has been changed, the requirement has been changed. If the requirement is the same, the contractor cannot initiate the requirement of variations.
so actually under the FIDIC contract, there is actually no provision for contractor to actually initiate a variation. But of course, in real life, you can actually, if it is really necessary, you can actually go to the employer and say, there are actually these things, we actually need a variation. Can you issue us an instruction? So at the end of the day, the instruction has to come from the employer.
Because what I believe that once the detailed design has been prepared, after the acceptance of that detailed design by party A and party B, you go for the contract signing, right? So once it is a contractual binding, the scope of work cannot be changed. If it is changed, then it must be from the employer side, then they can go for the variations. But a contractor cannot initiate because the detailed design is prepared by the contractor by knowing all kind of requirements by the employer. So he cannot initiate contract. I don't believe that. I wanted to know more about it.
Yes.
How a contractor can ask for the variation.
Yeah. So I mean, one of the things I can think about is actually, if there is actually change in law and the employer is actually not doing anything, then you can actually go and sort of nudge. Actually, at the end of the day, legally, contractually speaking, it will be employer initiating the variation. But of course, if, like I say, if the contractor really sees a need for variation, I don't know, for whatever reason, you have to go to the employer. You cannot say, I want a variation. You have to go to the employer, explain to them why the variation is needed. And, then if the employer agrees with you, they have to issue an instruction. So,
because in this case, what I have learned from this, we have executed this EPC project for 4 years. Once the requirement has been clearly mentioned in the RFP or in the preliminary design, it only belongs to the contractor to prepare the detailed design according to the requirements. Because while you have to prepare the detailed design, a contractor has to go on the site, do the geographical studies, geotectonics, topography, and hydrological and soil investigation studies. If something is happening on the site during the execution, so it's all relevant to the contractor. It doesn't mean the employer will not facilitate it because it is EPC. The detailed design has been prepared by the contractor. So now contractor is responsible if he is facing any unforeseen issue. Yeah, because he was responsible to do the site investigations properly.
Yeah, I agree with you. So I think that is exactly why the reason why the FIDIC Silver Book doesn't provide for provisions for contractor to actually initiate the variation. And instead it actually provides for grounds for contractors to reject the variations. So so like I said, contractually the variation has to come from employer. Then the contractor assess whether it falls under one of the grounds where the contractor can actually object the variation instructions. So I mentioned 3 grounds just now. Just to recap, the goods required for the variation works cannot be readily obtained. Secondly, the variation works will reduce the safety or suitability of the works. Thirdly, there will be adverse impact on the achievement of performance guarantees. So those are the 3 initial grounds under the 1999 version. So there are some new grounds in the 2017 version. So basically the 3 grounds that are listed here. Varied work was unforeseeable having regard to the scope and nature of the works described in the ER's employees' requirements. Then or it will adversely affect the contractor's ability to comply with the health and safety obligations or those regarding protection of environment. Third new ground is, yeah.
The silver book cannot. Under the silver book, if you are dealing with the silver book, you cannot. If you are dealing with the red book, yes, you can.
So yeah, you mentioned value engineering. So under the FIDIC Silver Book, yes, you can submit a proposal for value engineering, but the scope for value engineering is actually much narrower than the variation because it relates to accelerating the works, reducing the cost for the employer. So basically anything that is beneficial to the project itself. So if whatever that you intend to propose, which will usually be the case, will actually delay the completion, for example, or will actually increase the cost, those would not be value engineering, and you cannot just submit a proposal like that. So yeah, like I said, under very limited circumstances, you might need, maybe there is a need for a contractor to actually propose variation. Best way, okay, so best way is, of course, you provide for it in the special provision when you're amending the general conditions. But if I am the employer, I would unlikely agree to it because I would tell you that's like you mentioned, that's your design. Why would you want the right to vary? I give you all the responsibilities to do the designs, and you produce the design, you tell me this is the best we can do, it can achieve whatever you want, and why would you want to vary it? I mean, like I say, one of the grounds I can think about is, there's suddenly a change in law that affects, affects your design. You have to add something to your design, or there are certain parts of your design that you have to change or actually delete, or you have to do some other things. Under those circumstances, maybe you provide it under the change in law provision, or you actually add that as a limited grounds for you to propose a variation. But under this kind of EPC or turnkey project, most of the variations would actually come from the employer. So like I said, that is the official way. Then of course, in practical, the unofficial way is really for you to talk to the employer in private, saying that we need this variation. So you issue us an instruction, or you issue us a request for proposal. We will give you a proposal explaining why we need why we need a variation. So, the request, contractually, the instruction or the request has to come from employer. So you have to sort of ask them to initiate the process, but of course you can be the one actually asking them to do it. But again, whether they will actually do it is up to them. So yeah. Yeah, so I will come to the site conditions in a bit. Actually, a big feature of this Silverbook, this EPC turnkey project is that the contractor is actually taking the risk for the site conditions. So whether you actually have, sometimes I understand that some contractors, they don't even have the chance to actually do proper study at the grounds, but they just have to accept the grounds conditions. So this is something that I will come to later, but just very briefly, most of the risk of the site conditions is actually with the contractor. So you can't actually request a variation if if the site conditions, anything that happens to the site conditions is actually within your risk. So yeah, so again, you just have to price properly, but of course there are some carve outs from the risk, which we will see in a bit. So yeah, still talking about variation, notwithstanding any objection, the employer's representative can actually still confirm the instruction. So yeah, so they can still ask you to proceed, but of course, the consequence of that is, of course, you will be claiming your cost or your EOT that you think that will arise out of this variation. Then a bit about the valuation of the variation. So usually it's valued based on the schedule of rates. If they are the same items or similar items, usually that's the basis for valuation. If not, it's usually just based on the market price and on the costs. So under the contract is on the cost plus profit basis. But yeah, what we see in practice is actually a lot of employers, when they are amending the FIDIC general conditions, they will actually ask for all the cost plus profits to be amended to just cost. So again, but that is something commercial. There's something to be negotiated between contractor and employer. So yeah, so most of the time, employers, of course, they would prefer to just pay you the cost. But of course, as contractor, you would want some profit because you would have incurred some other
experience that the fat component is a little bit compared to the other one. Because in EPC projects, we cannot ask for the escalations as during the construction, the escalation will not be important. So, and also the BOQ is also a non-binding item as per the preamble of the document.
BOQ is a non-binding item. So the BOQ cannot be, if something is, if the quantity of the sand has been 200,000 cubic meter, and on the side I'm going to use 210,000 cubic meter. So I cannot ask the employer to give me the variation. Yes, and if employer will also not determine either I use the 200,000 or either I use 150,000. I save the 50,000 quantity, so that is a profit for me. Yes. But escalations cannot be opposed in
yeah, we'll come to the contract price bit part in a bit, but yeah, generally it's just a lump sum. It's inclusive of everything that you need to do to complete the project, to achieve whatever requirements under the project, and like you say, it's not subject to escalation. So you can't suddenly tell the employer that, oh, I need to increase the price by 10% because all the raw ingredients, all the prices have gone up. These are actually your risks. So yeah, we'll come to that in a bit. So one thing about the variation under this 2017 FIDIC contract is actually there is actually the whole process of claiming the EOT and the cost is actually contained in the clause itself. So variation is clause 13. There is a general provision on claiming cost or EOT or whatever thing under the contract, that's clause 20, but clause 20 doesn't apply to variation claim. So you have to look at this clause 13 itself on variation claim. So this clause 20 only applies if let's say the employer asks you to submit a variation proposal, you've submitted already, then the employer decides, they decide that, oh, I'm not going on with this variation. So under the current 2017 version, it actually allows you to claim costs for preparing the variation proposal. So if you are claiming that cost, then you have to claim it under the clause 20 process, which I'll come to it a bit later, because the whole process is now a lot more complicated than before, and it applies to both employer and contractor. So for claims, again, claim is now a defined term. So what does it mean? It actually refers to both the employer's claims or the contractor's claims. So if the employer thinks that they are actually entitled to payment from the contractor, or the contractor thinks that they are entitled to additional payment from the employer or EOT. So, and also any other types of claim apart from time and money. So like I mentioned, this clause 20 actually sets out the procedures of the parties to make a claim. So it's much more detailed under 2017 Silver Book compared to the 1999 version. And it is actually the longest clause in the whole Silver Book. So it now applies to both the employer and contractor, which I would say is actually a good news for the contractors. Because previously under the 1999 version of the Silver Book, the employer's claims is actually governed by a separate provision. And I would say the provision is a lot less stringent for the employers, because the employer still needs to give a notice or something, but there's no strict time bar to it actually. So they have to give the notice as soon as reasonably practicable, but there's no time bar to it, and there is no mention of the consequence of not giving the notice. So let's say if I am under the 1999 version, if I am the employer, I have a claim against the contractor, I give you a notice, I actually give you the notice super late, it actually doesn't bar me from still proceeding with the claims against you. Whereas under the previous version, there is a few notice or documents that need to be submitted by the contractor for claims. A very important one is the first notice. So first notice of claim, within 28 days, you have to give. If you do not give the notice, you are actually barred from claiming. So the notice is actually, a sort of condition for the contractor to initiate their claim. So you don't give the notice within the time, that's the end of your claim. You go for dispute resolution, likely your claim will be rejected because, it is stated clearly in the contract that you are basically waiving your rights to claim, and the employer would not have any liability for this claim, to you if you don't give the notice. So that is the position under the 1999 version. So it's a bit unfair, employer can just take their time while there's this strict time bar and process that has to be complied with by the contractor. I mean, under the 2017 version, the time bar, the strict provision, the procedures, they are all still there, but it applies for both employer and contractor. So now even when employer dealing their claims, that they are subject to the same process. So they have to give the notice. If they don't give the notice, they are basically waiving their claims. So this is some sort of good news. I mean, it is a very stringent provision, but now employer suffers together with the contractor. So yeah. Then the last point is I mentioned you have to go through the claim process before a dispute can arise. So these are just some of the new provisions entitling the contractor to actually claim EOT or additional payment. Then these are for the employer to claim to additional payment or the reduction in the contract price. So what are the common disputes over these variations and claims? Number one is whether a valid notice has been given. So this is, like I mentioned, this valid notice of claim is actually a very important thing under the FIDIC contract. Because to be honest, I have not seen any project that has no claims for EOT or additional payment in my years of practice, although it hasn't been super long, but yeah, I've not seen any project that don't have it. So under FIDIC, it is particularly important for you to give a valid notice of claim, because that is what keeps your entitlement to continue claiming, because afterwards there's the whole process of giving the fully detailed claim and whatnot. But this is the first step, and it is something that you have to comply with in order to be entitled to continue claiming. So if you don't even comply with this first step, it's basically the end of the story for your claim. So then of course, like I mentioned, there are the procedures of claims under the contract. This is something that you must follow through for your claims to be allowed. So again, you don't want to lose out on your claims purely on the procedural grounds. In disputes, we always see that people object on procedural grounds, saying that you haven't complied with this and that, so you shouldn't be allowed to claim. Ideally, when we go and argue over how much we are entitled to claim, ideally we should, we want the argument to be on the merits of the claim. So, how much I'm actually allowed to claim, how long EOT should I be granted, rather than, whether you have give the notice in 28 days or you give it in the 30th day, which is like out of time. So you don't want these kind of arguments to come up. Then of course, I mentioned that the employer's representative agreement determination, whether this enhanced role of this employer's representative would actually reduce the dispute. So this is, so you see these 1, 2, 3, 4, 5, 6, 7. These 7 points are actually the requirements of FIDIC contract on what a formal notice of claim should be. So if you miss out in one of these, then there will be risk that your notice of claim would not be valid, and you are not even entitled to initiate your claim. So so the 2017 Silver Book is very prescriptive, and it is very clear on how a valid notice of claim should be. So firstly, of course, it must be in writing. It must say that I am a notice, basically identifying itself as a notice. Then it has to describe the event or circumstance giving rise to your claim. So why am I claiming? Then so you have to give it not later than 28 days of you becoming aware or should have become aware of the circumstance. Then you give it to the employer's representative with a copy to the other party. So if you are a contractor, you give it to the employer's representative, and then you copy it to the employer. So the last 2 points are actually, for me, they are actually very important, and they are usually overlooked by parties. One is that it has to be sent in the correct form and mode of delivery and signed by the person that's authorized to do so. A lot of people, sometimes, when the project lasts for years, the address or the persons that you're talking to actually change. So it is quite important actually to keep updating the other party of the change in let's say your authorized representative or like your address and whatnot. But a lot of times parties don't do it formally. So for example, my address in the contract is actually Cosmo Hotel, but actually 2 years down the road I've actually moved into another place. But but to give a proper notice of claim, you actually should have addressed it to the address under the contract, because there is the proper address for communication provided under the contract. So in real life, we know that things have changed, but you have to ensure that you actually do the notice of claims properly. I mean, other correspondence, day-to-day correspondence is fine, but this you have to comply, because they will have quite serious consequences if you don't comply with it. So we usually tell the clients that just send a copy to whatever address that is said in the contract if it has not been changed. So even if it is not applicable anymore or something, just send it, or address to the person that might have actually left the place, but still address it. I mean, it can be received by it can be practically received by another person in the end, but ideally you want to comply with whatever that is said in the contract itself. So
if it is not received by the employer, after appointing the AER, a contractor and a client cannot communicate directly, right? They have to go through the AER, and the contractor must come from the AER. So the copy shall be sent to the AER and a copy sent to the employer. If employer does not get the copy of the notice of claim within the time, but the employer representative have got the copy within the time, so this situation will prevail to accept the claim, because the employer representative is appointed by the employer.
Yeah. So like I say, the point before, it is actually given to the ERs, but of course it is also a contractual requirement to have a copy to the employer. So what I'm saying is that when you are copying to the employer, just send it to whatever address that is stated in the contract, even though it might be outdated, even though you might know in fact it's outdated, then just send 2 copies. I mean it won't cost you much, but an invalid notice of claim might cost you a lot of consequences. So you might you want to do it so to protect your own interests. So these procedures of claims. Okay, so now the procedures of claims is actually, it has gotten a bit more complicated. So so the initial notice of claim is the initial notice that I mentioned just now. So you give it within 28 days of you becoming, or should have become, aware of the relevant event. So the consequence of non-compliance is that you are actually barred from asserting your entitlement to the claim. So, and then the other party is discharged from liability. So basically you lose your claim. So it is very important for you to give this notice. I mean, a note is that, it may be waived by the employer's representative for extenuating circumstances, but really in real life, this usually, it rarely happens, because what are the extenuating circumstances for you to not being able to give a notice of claim within 28 days. So for this to be extended is usually very rare, and likely that it will be objected by the other party as well. So the second one is a new thing under the 2017 version. So in the 1999 version, you have to give a notice within 28 days. If you don't, that's sort of the end of the story for the claim. But in the 2017 version, there's this new thing on initial response. So let's say you send me a notice of claim. For me, I think that it has been 30 days, you are already time barred. I actually have to give you an initial response within 14 days, saying that you are time barred. So you cannot give me this notice because you are time barred. You are no longer entitled to a claim. That's the end of the story. I actually have to tell you that within 14 days of you sending me a claim, if I don't do this, then the notice of claim will actually be deemed to be valid. So let's say the contractor actually sends in the notice of claim, 40 days after. I'm the employer. I'm the employee's representative. I receive it. No one says anything within 40 days of receiving. Then the notice of claim, even though it's not sent within 28 days, is deemed to be valid. So, now there are things to be done by both parties. So if I think that you're out of time, I have to tell you. If not, you can actually proceed with your claim. Then there's this fully detailed claim. So this one you have to be a bit careful because a lot of people actually thought the 84 days is from the time when you send your notice. It's not. It's actually from the time when you become or should have become aware of the relevant circumstance. So the starting point is the same. So let's say 1st of April is the date when you become aware of the circumstance. 28 days from 1st of April, you have to give the notice. Then 84 days from the 1st of April, you have to give the fully detailed claim. It's not from the date when you send your notice. So you have to be aware of the timeline. And there are a few items that you need to include in your fully detailed claim when you are sending it in. One of it is you have to actually provide a statement of the contractual or other legal basis that you are claiming under. So let's say if I'm claiming for cost of variation proposal that the employer is not proceeding, then I have to say that under this whatever clause, it allows me to claim the cost and I'm claiming the cost. So that is the contractual or legal basis that you have to talk about. Again, if you don't give this statement, then the notice of claim will lapse and it will become invalid. Again, this is something that that you have to comply with. If not, it affects your claim. But a complication to this particular provision is that there are actually a few items that you have to give for a fully detailed claim. And only not giving this particular item a statement of contractual or other legal basis has this consequence. So actually, if within the 84 days, I'm not able to give you a fully detailed claim, I can actually just give you this statement of contractual or legal basis, and it will actually sort of keep my claims alive, because not giving other detail doesn't have the same consequence of making your claim invalid or lapse. So again, it may be waived by the employer's representative. Then the last situation is if it's a continuing claim. So at the time I'm claiming, the whole thing is still continuing, the whole delay is still happening. The cost, I'm still incurring costs. So, you have to basically submit your interim claims monthly, and once the event expires already, then within 28 days I have to submit the final fully detailed claim. So next point is on the employer's representative agreement or determination. I've mentioned this a few times. So clause 3.5. Then again, there is actually a strict timeline and the time bar to this agreement or determination. So I think what's important is what is the effect of a determination by the employer's representative. So basically, whatever that the employer representative has decided, it is actually binding on the parties until you actually refer it to the dispute resolution at the and is actually changed or revised by either the DAAB or the arbitral tribunal. So so maybe I will go straight to this figure. Maybe it's a bit clearer. So you see the whole process. The first one is actually the engineer will actually try to come to an agreement first. So when, okay, here says engineer because this figure is actually for red and yellow book, but whenever it refers to engineer, it actually means employees representative under the silver book, but the process is exactly the same. So the employees representative, whenever there's a claim, they'll actually consult with both parties first, trying to reach an agreement within 42 days. So if they reach an agreement, then there's a notice of parties agreement, then that's binding of the party already. But if there's no agreement, so agreement reached. If there's no agreement, then the engineer the employees representative actually have to go and determine the claim. So when they are determining the claim, there are three outcomes actually. So if they actually determine the claim, there is binding of the parties. If it doesn't determine the claim, then they reject the claim, then they can refer to dispute resolution. If they actually don't say anything, so within 42 days they have to decide. So if within these 42 days they don't decide, it is actually regarded as the employer's representative having rejected the claim. So if I receive a claim from you, I just sit there and I don't do anything for 42 days, then after 42 days, your claim is deemed rejected. So this is important. So if it is deemed rejected, then I have to actually give a notice of dissatisfaction within 28 days. So maybe this one. See, there is a new time bar. So if I am not happy with the employer's representative determination, I have to actually give a notice of dissatisfaction within 28 days of receiving the notice of determination from the employer's representative. Because if I don't give this notice of dissatisfaction, it is actually deemed that let's say the rejection is actually binding on me. So let's say I submit a claim already, the employer's representative actually rejected the claim, and I just don't say anything, I don't give this notice of dissatisfaction, then it is deemed that I have accepted the determination and it will be binding on me. So you have to give this notice of dissatisfaction before you can actually go for dispute resolution. So again, a lot of notice requirements under the FIDIC Silver Book. You have to make sure that you are actually very familiar with it, because there are all these consequences of not giving all these notices within these numbers of days. So one of the things that people usually would revise in their special provisions is if some of the employees or contractors, sometimes they might have a small team, or one team is handling a few projects or things like that. So sometimes they think that maybe 28 days is too short for me. I need longer time. Then sometimes they will actually revise all these timelines under the contract. So the timeline can be revised to suit the everyone's practical need. But at the end of the day, usually people will still prefer to preserve all these procedures so that there is certainty in claims. So whether I decided yes, whether I decided no, or whether I don't do anything about it, then there are all these deeming provisions that will actually allow the parties to know how to actually proceed with the projects. So some practical steps to ensure the compliance with the notification and the time bars. One, of course, you need to be familiar with the process. So you need to be familiar with, how many days you have to give this notice. Then afterwards, within how many days you have to give the claims. What are the consequences of this, of giving or not giving certain things. Then you have to know the difference between time bar and time limit. So time bar is something that actually bar you from claiming further if you don't comply with it. Time limit is still something that you have to comply with, but the consequence is not as bad as a time bar. So time limit, let's say within the number of days, I have to submit these claims, but it doesn't really say that I lose my entitlement if I don't comply with it. Then technically I can still submit after the time limit, although there's a small breach of the timeline, but the consequence is not so dire to the extent that I lose the entire claim. There are actually, possibilities for me to continue with my claims. But of course, whether it's time bar or time limit, our advice is always that please comply with them. And next is also always keep proper records, because this helps you to prepare your fully detailed claims, especially because the notice is actually not difficult, because the notice only needs to set out very limited details of what you're claiming. But the fully detailed claims is actually where you need to give all the details required for you to claim your EOT or additional payments or something. And the information and documents should be enough also for the employer's representative to afterwards determine your claim. So, and the timeline, like you see, is not very long. It's actually 84 days from when the event actually arises. So it's not long, and keeping a proper records of everything will actually help you to prepare the necessary documents and information required. Next thing is, don't leave things last minute. Of course, there are 28 days for you to, to give your notice, but nothing is stopping you to give you, 5 days after, if you can do it. Because, leaving things, the danger of leaving things to last minute is, people might start disputing, when is the starting date to count the days. So for example, I say 28 days from the date when you become aware or should have become aware of the event. But when is that? For me, it might be 1st of April, but for the other party, they might say, oh, it's actually 20th of March. Like you should have known about it on 20th of March. So, the starting date to count all these days might be in dispute as well. So don't leave things to last minute. If you're able to, do it as soon as you can. Then if you are in doubt or if you require it, we also, of course, this is not for me to sell myself, but yeah, do engage external helps if you need to, especially for your claims of EOT and additional payments. You have to think about, whether your internal team is enough for you to actually come to a delay analysis or cost analysis, or you need to actually engage external delay or quantum consultants to actually do it. Because, engaging them early might help, because if it eventually goes to dispute resolution process, you will need these external helps to actually come up with these, third party, expert reports or something to support your claims. So, if you require the experts' helps, then yeah, do get them in early. So so this will be the next part. Can we have like a 5 minutes break? So 5 minutes toilet break, and then we'll come back to this. Hi everyone, welcome back. Yeah, so we go to issue 2. Don't worry, we're already halfway there. this thing is not working.
Pointer is not working.
Thanks. Yeah, I thought we'll get stuck at these slides for the okay. So just talking about the key risk allocation in Silverbook. Like I say, the 2017 version, the risk allocation is the same as the 1999. So primary risks are all on the contractor. So design, procurement, construction, performance of the completed facility. Employer's risk is basically it's a minimum risk for the employer, because their primary obligation is really to give you access to the site, to ensure that whatever permits that they need to have are in place, and to make payments to the contractor. So for unforeseen conditions, generally no adjustments. For example, like I mentioned, for example, adverse grounds conditions, no adjustment to the price. There are some provisions on force majeure. So force majeure is now known as exceptional events under the 2017 Silverbook. So for example, natural disasters or war, these are force majeure that it may entitle the contractor to EOT, and in some events, it actually entitles the contractor to costs. Then for insurance and indemnities, again, the contractor is getting most of the insurance, including those relating to the damage to the works, the party liability, professional indemnity. Then performance security. At the very beginning, I mentioned briefly about these performance security provisions. So this is basically, it can be called other things in other types of agreements, but this is basically the performance bond, the bank guarantee. Basically, it is to warrant the contractor's proper performance of the obligations under the contract. So this performance security, it will be in the form to be attached to the agreement. So what is typically done in practice is that there will be a preferred form by either the employer or the contractor, and then it will be attached to the contract. So the performance security to be issued by the contractor to the employer should typically follow that form. And normally this kind of performance security, it will be an unconditional and on-demand bond. So what that means is that between the employer and the bank doesn't question, the bank doesn't really question why the employer is making the demand. Once the employer writes into the bank saying that I'm demanding the full amount or half of the amount of the bond, the bank is supposed to pay. There's no condition to payment. So this is what we usually call an unconditional on-demand bond. Some of the other provisions you have to think about whether you need in your security is also whether it is actually assignable to the lenders. So some employers would actually request that the performance bonds can be assigned to the lenders without getting the consent of the bank or the contractor. So that might be one of the requirements under the contract, but there's no default requirement of this under the contract, but parties can add that in if that's required. So I also mentioned briefly just now that performance security is one of the provisions that you have to state the amount in the contract data. So let's say you say 5% of the contract price. You have to state it in the contract data. If you don't say anything in the contract data, you leave it blank, then this provision is not applicable. So no performance security is going to be issued to the employer under the contract. then we go into some of the key responsibilities and obligations under the FIDIC contract. Firstly, the design responsibilities. So typically there will be employer's requirements. The employer in their RFP, they will actually give you the requirements. So these are not the detailed designs, but these are just the requirements on, the employer's requirements on how, they expect the finished product to work, to operate. So then the design responsibility is actually on the contractor. So you basically design in accordance with the employer's requirements, in accordance with whatever performance that it is intended to achieve. So the contractor actually gives a warranty under the contract that the contractor or whoever designer that they engage will actually have the experience, capability, and competence necessary to do the design. So contractor undertakes the design, the execution of the design, and complete the works in accordance, with the laws, with the technical standards, with the employer's requirements. And the contractor is actually under an obligation to correct any error, omission, or defects in the design. So it is at the contractor's risk and cost, basically. So you see the last point. The contractor is actually deemed to have scrutinized the employer's requirements, including any design criteria and calculations before the base date. So base date is a date which is quite important in the FIDIC contract. It is defined as 28 days before the latest date for submission of a tender. So this base date is usually used. For example, this is actually, so any design criteria and calculations before the base dates, these are actually all your risks. So you would have been taken all this into account in coming to a price, in coming up to a design. So you are actually taking risk of all this. But there are some carve-outs to the design responsibilities. So employer remains responsible for this. So firstly, the portions, data, and information that the contract states are immutable or the responsibility of the employer. Secondly, definition of the intended purpose of the works or any part of the works. Thirdly, criteria for the testing and performance of the completed works. And fourthly, the portions, data, and information that cannot be verified by the contractor, except as otherwise stated in the contract. So these are basically carve-outs. So if it falls within, any of these, the employer actually retains responsibilities. But one of the issue we have in practice is, what is the extent of these information which the employer retains responsibility for? So in practice, we actually usually see these provisions being amended, to actually clearly list out, what are the exact documents that are at the employer's risk and what are not. So that is actually preferred. But again, if you are actually, for example, if you are actually amending this to actually limit so let's say I actually remove all these and I actually just list out, say 5 or 10 documents that I say, these are my responsibilities, the rest are yours. Of course, you can do that, but of course, the consequence is that the contractor might raise the price because they're actually regarded as taking more risk. So, this risk allocation, if you are amending it to alter the risk allocation in the contract, what you can expect is that, the price would be adjusted to take into account the risk. Second thing is this, I also briefly mentioned it earlier, this fitness for purpose obligation. So in the 2017 Silver Book, it actually talks about a wider fitness for purpose obligation. So it says that when completed, the works shall be fit for the purpose which they are intended as defined and described in the employer's requirements, or when no purpose are so defined and described fit for their ordinary purpose. So basically, the contractor is giving a warranty that whatever is built would be fit for the purpose that is intended by the employer. What the issue is, what does that even mean? What is fit for purpose? So now the 2017 Silver Book actually says that it should be defined and described in the employer's requirements. So ideally, the employer's requirement will talk about, what's the purpose of whatever that needs to be built. If it is not stated there, then the contract says it is fit for their ordinary purpose. Again, what is ordinary purpose? So there is some ambiguities to this particular term. So a lot of people would seek to actually define what is the purpose, so that they can actually limit the consequence of this clause. Because as you can see, the second bullet point, a consequence of this fitness of purpose obligation is actually an indemnity. So you are actually, the contractor is actually obliged to indemnify the employer against, all the acts, errors, or omissions in carrying out the design when the works completed are not fit for purpose. So this is a very wide indemnity. So basically, it is talking about, if the employer suffers, loss because your design is not fit for purpose, whatever that means, they can actually ask you to indemnify them. And indemnity is basically you are sort of reimbursing them for their loss. So this is actually quite a strict obligation for this fitness for purpose obligation, because this fitness for purpose obligation, like I say, it is something which is rather ambiguous, if you don't properly define it in the employer's requirements.
I would like to ask, what could be the solution for this kind of situation?
Okay, so I actually mentioned it. So for me, this fitness for purpose obligation actually relates to the design responsibilities and requirements. So at the end of the day, because it refers to the employer's requirements, ideally it should be properly said, in the employer's requirement that these are the purpose of this project. We are building a power plant to, supply electricity to this area. So that is clear, that is the purpose. So if, there's any design flaws that cause, any issues in the supply of electricity or the generation of electricity, then that is quite clear that, it is failing the fitness for purpose obligation. But like I mentioned, the real issue lays in not even trying to define what is the purpose. So, if you don't define it in the employer's requirement, what I can see potential practical issue is that, firstly, when something wrong happens, employers will actually look to this fitness for purpose obligation and try to say that, whatever you build is not fitness for my purpose. And if it's not clearly defined the employer's requirement, I am sure that they will try to find, somewhere obscure in the employer's requirement, somewhere hidden there, and says that, oh, I actually mentioned here that's the purpose of this project. That's the first issue that I can see. Second issue is that, okay, if no purpose is defined or described in the employer's requirement, fit for their ordinary purpose. This, I would definitely argue that, oh, you know very well that what a power plant does. So, if your design flaws cause me, disruption in the generation, then of course it's not fit for ordinary purpose. But an issue with that is that, everyone interprets ordinary purpose as a different thing. So what I can see that there will be quite a lot of disputes surrounding this clause, especially when there is actually an indemnity to it. And like I mentioned here, there is actually a provision saying that the employer can actually require the contractor to extend their professional indemnity insurance to cover this fitness for purpose indemnity, which in practice I've not seen how it will work because I am not sure how this indemnity, this risk can actually be insured.
Under the EPC contract procurement procedure, once the preliminary design is prepared by the employer, the requirement of employer has been portrayed properly. One thing. Second thing, once the contractor provided the detailed design on the behalf of that preliminary design provided by the employer, that detailed design is get evaluated by the employer before going for the contract signing.
Yeah. So you see that's exactly the issue. So you, like you said, there is actually some sort of review or approval process by the employer, but at the same time, contractor is still retaining responsibilities for their design. So how does it reconcile? So when something goes wrong, actually most of the time, the risks are still with the contractor. So if I am the employer, I can say that, oh yeah, it looks, when I'm reviewing your design, you are the expert. I look at your design. Yes, you tell me that it complies with all my requirements. It will achieve whatever performance guarantees that's in my requirements. But it is not, it's not what's going on now. It's your risk I'm claiming against you. It's not fit for purpose. So the issue I see with this fit for purpose obligation is really, it is quite an easy fallback for the employer. Because if I am the employer, I'm either not defining the purpose of the project, or I am going to define it so widely that if there's any failure, I can always go back to this fitness for purpose clause and say that, see, this is the purpose that this is one of the purposes I mentioned in my employee's requirement. Whatever that you build is not working, so I'm claiming this against you. So so far I haven't really seen any dispute arising from this clause, but I can see that if this 2017 Silver Book is more widely used, then this obligation might be an issue. So I can see contractors actually negotiating out of it. So if I am representing the contractor, I would say that either you remove the indemnity or you just remove the whole clause altogether, because this is actually, I would say, quite a risky clause for the contractors.
To mitigate with this risk, what we do the joint technical working studies with the client and organized by the contractor, and those joint technical working group, after that the duly signed by both, this kind of risk will not rise.
Okay, so the next one, also briefly mentioned just now, the ground conditions. So again, base date. So before the base date, the employer will provide all relevant data. Then the contractor is actually responsible for verifying and interpreting the data. Then they have to satisfy themselves as to the correctness and sufficiency of the contract price to cover the ground conditions. They would be deemed to have obtained all necessary information regarding the risk, contingencies, and other circumstances. They actually accept total responsibility for having foreseen the difficulties and costs of successfully completing the works. And they are actually not entitled to claim additional time or money if it encounters any unforeseen difficulties or costs in completing the works due to these ground conditions. So this is this is actually something that is important, especially if the contractor doesn't really have the chance to properly go and investigate or survey the ground conditions, because you need to know that you are actually taking all these risks. So you see, it's actually made clear that the employer has no responsibility for the accuracy, sufficiency, and completeness of any data provided, except to the extent that the contract states that the data is immutable, or the employer's responsibility, or it cannot be verified by the contractor. So again, these exceptions are a bit ambiguous. Arguably, any data that's provided by the employer might fall, one way or the other. So yeah, so this is, these exceptions, these carve-outs is, I would say, is not entirely consistent with the traditional turnkey approach. So I would see that, in real life, it will be heavily negotiated. Okay, the next one is extension of time. So yeah, I listed out the events that allows claim for extension of time. So if there's an asterisk, then these are actually new events under the 2017 Silver Book. So there are quite a lot of events that allows claim for EOT. So one issue that I would like to highlight is actually the issue on concurrent delay. So in a lot of contracts that I deal with, usually, because there is no, at least in the context of Malaysian law, there is actually no default position in relation to concurrent delay. So concurrent delay means that there are two delays that are ongoing at the same time. So for example, the contractor is causing delay, but at the same time, the employer is also causing the delay. So two events are actually concurrently happening. So who takes the responsibility for the delay? Because technically both parties are at fault. Who takes the responsibility for the time and the cost for the delay? So now this wasn't that way in the 1999 Silver Book. Usually parties will add a provision on concurrent delay in the contract. Now the 2017 version, they actually talk about it in a very brief way, actually. So there's this clause 8.5. It says that where there is a concurrent delay, the contractor's entitlement to EOT shall be assessed in accordance with the rules and procedures in the special provisions, if not stated as appropriate, taking due regard to all relevant circumstances. So still, it refers to the special provisions. So in the special provisions, you need to provide for how the risk of concurrent delay should be allocated. If not, it falls back to this as appropriate, taking due regard to all relevant circumstances, which ultimately it will likely cause a dispute, because both parties are standing from a different viewpoints, and for them, relevant circumstances might be different for each party. So from the contractor's viewpoint, maybe I'm thinking that my event only costs 20% of the delay and the employer causes 80%. So you should give me 80% of the EOT or the cost. But employer might think otherwise. Employer might think, regardless, both of us are at fault, maybe 50-50, or because you are also at fault, you are not entitled to anything, So these are the possible arguments that may be raised by the employers. So then clause 17.2, it talks particularly in the context of loss and damage to the works. So if there is a concurrent delay causing any loss and damage to the works, then contractor is still entitled to claim a proportion of the EOT or the cost plus profit. So this is clearly provided, where basically it says that if there's a concurrent delay causing loss or damage to the works, if the employer's fault is 50%, my fault is contractor's fault is 50%, I can claim 50%. So basically, I'm claiming the portion where the employer is actually contributing to the delay event. But this is only in the context of loss or damage to the works. So if there is no loss or damage to the works, it still falls back to this 8.5 where it needs to be set out in the special provisions. So one of the issues in practice is in the 2017 FIDIC contract, for at least for the claim for extension of time, there's actually no express obligation for the contractor to avoid or mitigate the delay. So if there's delay, and it's one of the events that allows you to claim EOT, then you can claim EOT. So there's no this general obligation to actually mitigate your delay. But in practice, we usually see the employer wanting to add this in because if the delay is 20 days and you can actually, through your reasonable effort, mitigate it to 10 days, then of course the employer would want it to be subject to reasonable effort of mitigation. Then secondly, some employers and lenders would actually want to narrow down the number of events that allow EOT claims. So because they want to have a more certain completion date. Because at the end of the day, EOT affects the completion date. So if I am expecting the project to be done by end of this month, but there are like 30 events for you to claim EOT, then eventually the EOT is 1 year, then that's not what I want. And that's not what the financiers or lenders want. So they might want to narrow down the situations, the circumstances where you can claim EOT, but again, this is something commercial or contractual. You can decide whichever way you want. But again, like I said, of course, if the events are narrowed down, for sure the contractors will raise the price because there are more risks to be taken. Then, like I say, for certainty, the special provisions relating to consequences of concurrent delay should be inserted. So you need to discuss upfront, whether you are sharing the risk or whether, employees taking the risk or contractors taking all the risk. So we do see some contracts actually provide that if there's concurrent delay, there's no entitlement for the contractor to claim whatsoever. So if two events happening together, contractor cannot claim because they are also partially at fault. But of course, that is usually not acceptable by contractors, but that provision usually happens when there is a huge difference between the bargaining power between the parties. So, that kind of clause, it might be seen to be a bit unfair to the contractor, but some of the contractors, they accept it. Either they are confident that they won't cause delay, or they just accept it because they want the job. So there are various considerations. Next thing is exceptional events. So previously it's known as force majeure, and I believe that's also the clause. There's also the term that is more familiar by everyone. So the exceptional event / force majeure is actually very, very widely defined in the contract. So basically, it just needs to fulfill these four conditions. So it's an event not substantially attributable to a party, beyond the party's control, could not reasonably have been provided against before entering into the contract, and could not reasonably have been avoided or overcome. So there is a non-exhaustive list of events that might constitute exceptional events. So when I say non-exhaustive, even if it doesn't fall within the list, it can still be an exceptional event if it fulfills these four conditions. So in order to rely on the force majeure provisions here, firstly, the affected party must be prevented from performing their contractual obligations. Then this is the reasonable effort of mitigation that I mentioned just now. Sometimes people will add this to the EOT provision, but by default, it's only applicable to the force majeure provision. So the affected party has to use reasonable efforts to minimize any delay and in the performance, and they have to demonstrate that the impact of the event could not reasonably be overcome. So generally, all the events allow you to claim EOT. There are some events that actually allow the contractor to claim costs. So one is war, hostilities, invasion, act of foreign enemies. So these other events are something similar to war, hostilities, for example, strikes, lockouts. Basically those events that are really out of the control and is happening at the country where the site is located. So let's say if both parties are in, say, China, and then the site is in Malaysia, something happened in Malaysia, then yes, then it's a force majeure where the contractor can claim the cost against the employer. So some issues in practice that parties usually think about. I think one thing is actually limiting the events of force majeure or exceptional events. So some employers would, similar to the EOT provisions, they would like to actually limit it. So some parties would actually turn the non-exhaustive list to an exhaustive list. So if it is an exhaustive list, because especially for Malaysia, force majeure is a contractual concept. So if it is not provided in the contract, there is no general legal concept force majeure. So you must provide it in the contract. So if in the contract I say force majeure is just war, then that is the only event of force majeure. You cannot claim anything else. So sometimes some parties, they would seek to actually limit the events of force majeure. Again, they want certainty. They don't want suddenly you coming and claim 300 days of EOT because of some government orders or something. So an alternative is to put a reverse list of events. So let's say there is the general conditions, there is a non-exhaustive list of events that qualifies as force majeure. Sometimes some parties, they add in another list of non-force majeure events. So I say 4 conditions. These are examples of force majeure events. But I also provide that there are certain events which are not force majeure. For example, it is something to do with the liquidation or the funding of the party. So if you are running out of money, for you it might not be reasonably foreseeable. You might not be able to overcome it, but that's your issue. I'm not granting you EOT just because you run into some financial problems and you cannot properly finance the project. So and you want EOT, that I'm not giving you. So some parties, they will provide this reverse list just to set out that certain circumstances these are not force majeure. Then I think another issue is also with the wording of the current provision of this 2017 Silver Book. So just now, like I say, it actually uses be prevented from performing its contractual obligations. So this, if you interpret this strictly, you have to be prevented from doing anything. So that means that this force majeure must have caused you not being able to do anything to perform your obligations under the contract. This is actually quite a strict obligations rather than some other force majeure provisions that we see is that you just need to be delayed in performance of your obligations. You don't have to be prevented. So Well, of course, this is arguable, but usually if you read the contract in a stricter sense, prevent is actually a higher threshold than you are just being merely delayed in the performance of your obligation. So sometimes we do see people amending the wording as well. Another one is actually the provisions that I mentioned that allows contractor to claim costs. Sometimes, actually most of the time, employer would want to remove this because technically, if it is forced majeure, there's no party is at fault. For example, war and all this invasion of foreign countries, employer is not at fault. So so is the contractor. So usually the employer would only want to give you the EOT, but they don't want to give you the cost because for them they are not at fault. Why are they bearing the cost of it? The next issue, which is always negotiated between the parties, is the liability caps and the exclusions. So the 2017 Silver Book actually provides that neither party shall be liable to the other for indirect or consequential loss or damage. So of course there are certain carve-outs. These are the carve-outs. So if this happen, then you can claim for indirect consequential loss. One of the issues of this is that the indirect or the consequential loss is not really defined. So most of the times what we see is parties actually, they either try to define it or they actually provide some of the examples of what are these consequential indirect loss, so that the parties reading the contract actually know what's the nature of this so-called consequential indirect loss. The most commonly seen one are, say, loss of profits, loss of goodwill, loss of use, loss of contract. This kind of losses, usually parties want to exclude that from most of the claims under the contract. So then, of course, then the carve-out, for the carve-out, parties may add more things to the carve-out. So, parties may say there are more things that are actually not subject to the liability cap. For example, what we usually see is if it is fraud, if it is something that is illegal or against the law, then usually parties want to carve out from this indirect consequential loss exclusion, because if you are cheating on me, if you are actually committing a fraud against me, of course I will want to claim whatever damages that I can claim, whether it's a direct or indirect damages I want to claim against you. So these are the usual carve out that we see. So yeah, so those are the issues relating to the obligations between the parties. The next part, we go to the payment mechanism under the contract and also, the issue of delayed payments. The contract price, like I said, the 2017 Silver Book is a lump sum price basis, and contractor takes the risk of change in costs arising from the design. So this is the provision in the contract actually. So the contractor is actually deemed to have satisfied itself concerning the correctness and sufficiency of the contract price. And unless the contract states otherwise, the contract price covers all the contractor's obligations under the contract and all things necessary for the proper design, execution, and completion of the works and remedying defects. Basically, your price has to cover all this. Then, of course, there are some grounds for you to claim additional payments. So I've set out these grounds. Again, the asterisk one are actually new grounds for you to claim additional payment. Then yeah, I also mentioned here additional cost or cost plus profit. So you have to read the provisions properly, because some of the provisions only allows you to claim costs, but some of the provisions actually mention cost plus profit, which means that apart from cost, you can actually claim profit on it as well. And as I mentioned it, you have to put, the percentage of the profit in the contract data. If you don't put it in, it will go by the default rate, which is like 5%. So these are the other grounds. So again, the provisions relating to additional payment, they are usually heavily negotiated, because again, of course, employers would want to minimize the chances of contractor claiming additional payments, as much as possible. So they might actually seek to limit the list, reduce the list. But of course, on the contractor's perspective, there may be some situations where you want to claim additional payments which have not been provided under the contract. So if you want to add to the list, you have to do it through the special provisions. Also, another point that is always being negotiated is the cost plus profit point. So there are certain provisions where the default position of claim under the FIDIC contract is actually cost plus profit. So you can claim your cost plus, default is like 5% profit. But like I say, a lot of employers will actually seek to remove those. So a lot of employer will actually want to pay you costs only. So that is again something that is usually heavily negotiated by the parties. Then there are some of the additional amounts that contractor might be able to claim. First one is financing charges for delayed payment. They call it this, which in essence is basically interest, late payment interest. Then there are also termination payment. They are payment under contractual indemnity. So the payment mechanism under FIDIC contract, the default mechanism is interim payment. So there is a schedule of payments. Usually it is either progress payment, it's either milestone payments or monthly payments. Of course you can do a combination of it, but usually the more commonly seen one are these three lah. Actually progress payments or milestone payments lah. Regular monthly payments perhaps, but but again, this is something that will be agreed by the parties. Then of course, if you are using some other basis for payment, I don't know what other basis that you want, but if you are using some other basis, you need to amend the general conditions through your special provisions. Then you have to be aware of these conditions precedent for payment. One is you have to provide the performance bond, if there's a performance bond to be provided under the contract. Then you have to have appointed your contractor's representative. So if you don't do one of these, no payment is due for you under the contract. So so at the end of each month, or any other period stated in the contract data, the contractor actually has to submit this statement to the employer. So it has to include all this. So basically you state all this, and then all these items, then in the end you will basically tell the employer what's the amount that's due for you. But of course you need to submit. The employer will expect you to submit supporting documents in accordance with this statement. It cannot be just one statement with one table with all these amounts without any substantiation. So after receiving the statement and the supporting documents, the employer would actually give a notice. So that notice is actually to inform you what amount does the employer think they owe you. So if you are claiming 1 million for this progress payment, the employer might come back to you with a notice saying that, oh, actually I think whatever works that you have done is actually just 500,000. That might be the case. But one good thing about this notice is that if there's any difference, the contract actually requires the employer to give a reasons for the difference. So if you are claiming 1 million, I say you are only entitled to 500,000. I need to say in my notice why I think you are not entitled to the other 500,000. Then the interim payments. So the interim payments, they are actually due within the period stated in the contract data. If you don't state it, is 56 days. After, again, the start date comes from when they receive the statement and supporting documents. So you see these 28 days to give the notice and these 56 days to pay, it all actually counts from the date when employer receives the statement and supporting documents. So it is not 56 days from the date of the notice. Then the last point is on employer's entitlement to withhold payment. One new thing about this 2017 Silver Book is actually the introduction of this new partially agreed final statement for final payments. So for final payments, as you all know, this is the last payment that you are actually claiming against the employer under the contract. So the process under the 2017 Silver Book is actually significantly different from the 1999 Silver Book. So there's this introduction of concept of partially agreed final statement. So if basically partially agreed final statement is you issue it when there are things in the final statement that you cannot agree. So let's say the claim for final payment is 5 million and only part of it is agreed and the other part is not agreed. Instead of rejecting the whole thing, actually this partially agreed final statement is actually issued. So so it will identify the agreed amounts, the estimated amounts, and the amounts that are not agreed. So there are a few things that will be contained under this partially agreed final statement. So together with this partially agreed final statement or final statement, the contractor is actually required under the FIDIC contract to issue a discharge. So the discharge will actually say that the statement represents full and final settlement of all monies owed to the contractor under or in connection with the contract. So one issue with this statement, with this discharge that the contractor needs to give is that it's actually it may not be appropriate because your partially agreed final statement will actually talk about amounts which are not agreed between the parties. So it actually cannot represent like the full and final settlement of all monies due to the contractor under the contract. And then there are provisions saying that if the contractor fails to issue the discharge, it's deemed to have been submitted. So all these provisions, in view of this, concept of partially agreed final statement, it may not be appropriate. So I think especially for the contractors, this is something that you have to take note, and of course you would want to actually amend it. Because this discharge is actually inconsistent with this partially agreed final statement. You don't want the employer to actually force you to issue this discharge, or they deem that you have issued this discharge and use this against you and saying that, even your partially agreed final statement, that is the full amount that you're getting. So you see, the employer will no longer be liable for any matter in connection with the contract or the execution of the works. And to the extent that the contractor has included an amount expressly for it in the final statement or partially agreed final statement, and the statement at completion except for matters arising after takeover. So this is where the employer's liability under the whole contract would cease. So in relation to this, the 2017 Silver Book actually introduces a new time bar. So if you don't make a claim in respect of an amount included in your final payment within 56 days, then, so for example, you receive a final payment from the employer, you receive 1 million, it is supposed to be 3 millions, let's say. Then you don't claim the other 2 millions within 56 days, then it is deemed that you have accepted the amount as correct. So it is deemed that you have accepted the amount of 1 million as correct, and the employer would have no liability whatsoever afterwards to actually pay you back the rest of the money. So of course, it doesn't limit the employer's liability under the indemnity, but it is something that you need to this is basically the final time bar for the contractor in the whole project. So you need to make sure that the employer pays the correct amount. Next, in relation to delay or non-payment, there are a few things that a contractor can do. Firstly, you can claim interest. So the default interest is monthly at the rate of 3% above the average bank short-term lending rate. So this is the default rate under the FIDIC Silver Book. But of course, it is something that can be amended by way of inserting the rates that you want in the contract data. Usually, what we see is parties would just put in a fixed interest rate into the contract data, because that's easier and that's more certain. If payments are not made, contractor can actually suspend the works. So you can actually suspend the works by giving a 21 days notice. I mean, then the next step is actually, you can actually go for termination. Of course, there are certain procedures that you need to follow, but it will be a ground for you to terminate non-payment. Then the next one is dispute resolution. Yeah. So I'll get my colleague Yap to go on with the final issue.
Hi everyone. So my part is actually dispute resolution. I think I'll just be standing. First and foremost, I'd like to thank everyone for having us here. So as far as dispute resolution is concerned, can I have a show of hands who has actually experienced this thing called Dispute Avoidance and Adjudication Board? Anyone has done it before? 3. Okay, thanks. So as far as Malaysia is concerned, just for background, as far as Malaysia is concerned, not many people will actually go for DAAB. I will come to that later. But just for general background, maybe I just outline some technical or some background knowledge in relation to DAAB, because I'm not too sure whether all of us are familiar with DAAB. So I suppose, like marriage, the success of a construction project depends quite heavily on the success of dispute avoidance. And if there is any dispute arises, a timely resolution of such disputes, right? So FIDIC strongly recommends that DAAB be appointed at the start of the contract, okay, and be remain throughout the process, so that the DAAB board can visit the site regularly and resolve any conflicts informally at the time throughout the process. Of course, this is ideal. I know that there are many instances that it is provided in the contract. It is not formed when the contract has been signed by parties. But these are what FIDIC strongly suggested. Right? So clause 21.1 of FIDIC provides that there are two alternative arrangements as far as constitution of FIDIC are concerned. There are two arrangements. First is sole member of DAAB. Second, there are three members. All right. So irrespective of whether one or three members, there will be a tripartite agreement entered between the contractor, the employer, and the member. Okay. If it is three members, then there will be three separate tripartite agreements with each of the members, employer, and also the contractor. All right. So then the parties are under joint obligations to appoint the member of the DAAB, which is within the 28 days from the acceptance, the letter of acceptance of the contract data. So each party will provide their own list. One party will prepare three members, the other parties will prepare three members. All right. If it is just one member, then from this 6 person, they choose one. If it is three members, then within this 6 person, it will choose three. So what happened if there is no agreement between the parties, right? Then there will be a impartial or neutral party that will be appointed. Usually will be the president of FIDIC. If it is provided for in the contract data, appoint a neutral party within this 6 person. All right. So let me think about it. Okay, so as an alternative to a standing DAAB, so what I talked about just now is the standing DAAB. The DAAB was appointed at the early stage throughout the process. But if it is not done, then a DAAB can be formed on an ad hoc basis, right? So on an ad hoc basis means that only if there is dispute arises that parties cannot resolve, then this DAAB will be formed, and the DAAB will cease to be in existence once the decision has been given. So if there is new dispute, a new DAAB will be formed. All right. So in this situation, more accurate reference to this should be the dispute adjudication board, because it doesn't have a function of dispute avoidance anymore. It just adjudicate the dispute between the parties. So now, aware of the time, so I will just quickly go through the process. Okay. So these are the topics. Actually, these are the small topics that I want to refer to. Dispute. So these are the backgrounds. I do not want to belabor on that. This is also the background. Key features, independent, all this. So you should make decision within 84 days when the dispute is referred to it. And if the decision is given, any parties that is not satisfied must give a notice of dissatisfaction within 28 days. Otherwise, it will be final. All right. So what happened after you have given a notice of dissatisfaction? If the contract provides for arbitration, then parties at the time can go for arbitration. Okay. So this is also what is the formalities of the DAAB. I suggest we will not go through that very. This can be in the slides. You all can go through it later. What I intend to actually share is that what about in Malaysian landscape? What do we do? Instead of DAAB, what we have in Malaysia is something called CIPA, Construction Industry Payment and Adjudication Act 2012. What happened is that if there is any dispute in relation to construction contract in Malaysia, then you can file a CIPA claim. The effect of a CIPA claim is that it is a temporarily final claim. All right, with that claim, you can actually enforce the payment. If parties doesn't go for arbitration, fine. You can use that to go for payment. And if you are the subcontractor, so the beauty of CIPA is that if you are a subcontractor, you have a main contractor, you have an employer. What you can do is with the CIPA award, if the main con doesn't pay you, you can straight away ask for direct payment from the principal. The employer can direct pay you payment. One. So this is a very powerful feature. Also, with the SIPA decision, you can also go for winding out of the company. So a lot of construction company, they will have no choice to pay out because they do not want the company to be wound out. So this is a very, I would say, powerful tool. And the process is very quick. The process is about 106 days from the day you submit the claim. So the purpose of this SIPA is to facilitate cash flow because under construction industry, construction project, cash flow is very important. By the time you go for arbitration, 1 or 2 years has passed. Where is the money? So this, you get the money first, all right, to run the project. If there is any issues that need to be maintained or need to be finally decided, it is before the arbitrators in the arbitral tribunal, all right? So this is peculiar to Malaysia landscape. In Singapore, there is a similar provision called SOPA. A similar provision as well. All is to ease the cash flow of parties. As far as DAAB is concerned, then there is one issue that the recent Court of Appeal has decided in the case of Aspen Glove against Kellogg Logistics. Is this parties have a FIDIC contract. The dispute resolution process is of course DAAB and then arbitration. Parties apply for SIPA. Then the issue is, if there is a dispute resolution clause for DAAB, then can parties for construction project in Malaysia file an adjudication claim under SIPA, right? Because you need to go for DAAB, not SIPA. So the Court of Appeal, majority decision of the Court of Appeal is that yes, you can go for SIPA. Effectively, you cannot even contract out of SIPA because it is a statutory right for Malaysian contract, for construction project, for construction construction services contract, that if there is any dispute arising from this project, you can ask for SIPA. You can go under SIPA for the decision to be given. All right. So as far as dispute resolution, I suppose that is all I want to share today. If there is any question, I would like to invite question as well. Yes.
One thing, sir. You have mentioned that a subcontractor can claim a payment from the employer instead of contractor upon the non-compliance from the contractor. It can only happen when a subcontractor is already mentioned during the procurement stage, while a contractor is submitting the tender document. He has mentioned for the specific component subcontractor. Is it only possible then, or directly he can? Because employer and subcontractor, they are not abide in other case.
Yeah. So in circumstances where there are a few situations where when the main con appoints subcon, they will there is already a tripartite agreement. So for your situation, the subcon doesn't know who are the employer, or it's not even mentioned who are the employee. It doesn't matter. As long as when you obtain an adjudication award, the employer owes money to the main con. Okay, the employer owes money to the main con. You write under section 30 of SIPA, you write to the employer saying that now, because of the SIPA, the main con need to pay me this amount of money. If there is any money that you owe to the main con, you pay to him, you pay to me. No problem.
So in that case, the main con does not have the right to go in the dispute and conflict that he have reserved the right for 5% savings or 10%, whatever the subcontractor and main contractor have the understanding.
Correct. So if there is any amount due, by the employer to the main con, that amount should be payable under the law, must be payable by the employer to the subcontractor. So
I'm trying to say that if I am a main contractor,
you are the main con.
I am the main con, and this guy is the subcontractor. I win the project in 10 billion rupees, in 10 billion ringgits from the employer, but I sublet the contract in 8.5. So the remaining 1.5 billion shall be given to because the employer is bound to pay the 10 billion. So what about that 1.5 billion? Either it will be paid to the subcontractor or the main contractor has the reserves the right to ask for that.
That have to depend on the specific interpretation and wording of the contract. So if based on the wording of the contract and also the account of the employer, if there is amount due, the test is just if there is amount due to be payable, then he has to pay. So if there is a dispute or whether there is amount paid, then the court will have to decide whether that is the amount due and payable by the employer to the main con. Very much depends on the wording.
I mean, maybe I can just add something to that. So in the situation that you are talking about, so the situation here when you can actually get direct payment from the employer is actually a situation where this subcontractor, they actually has already obtained an adjudication decision. So under the Malaysian the statutory adjudication SIPA, so this subcontractor has actually obtained an adjudication decision against the main contractor. So the decision is saying that, so in your situation, the decision would already say that, the main contractor owes the subcontractor 8.5 billion. So if, let's say, the employer is owing 10 billion to the main contractor, so subcontractor can actually directly claim that 8.5 billion from the employer. So the employer would, of course, pay that, subject to certain procedures, pay that 8.5 billion to the subcontractor straight. Then the money due and owing from the employer to the main contractor would be reduced to 1.5 billion. I think that's what you're talking about. If there's actually surplus of whatever that the employer is owing the main contractor, then yes, those money will remain due and payable and owing from the employer to the main contractor. Yeah, if the surplus won't go to the subcontractor. Basically, the subcontractor is only entitled to whatever payment that they are entitled under their subcontract. So there won't be extra amounts that they are entitled to.
Perhaps since I'm talking about dispute resolution, while this is not under the topic, one of the things perhaps I would just want to share with everyone is perhaps the issue of performance bonds, which is quite usually the issue of dispute between it could be between the main con and subcontractor, or it could be between the employer and the main con. So in Malaysia, of course, the law is that if a performance bond is unconditional and on demand, the moment you call the performance bond, then the bank have to release the amount stated in the performance bond. But what will happen is that when a party called the performance bond, the party that wanted to resist the calling of the performance bond can quickly run to the court to get an injunction against the calling of the performance bond. And the grounds under the Malaysian law for contracts that governs by Malaysian law is that the call of the performance bond is unconscionable. So what does the meaning of unconscionable, right? So one of the cases that we did was that the client actually had a meeting. The main con and employer had a meeting, for example, today, to discuss about the issue of the scoping, to discuss the issue of variation. All right. No, certain agreement has been entered in relation to that, but one of the issue is that the other side, the subcon, asked that our client not to call on the performance bond. What happened was that the client the next day called on the performance bond. All right. So in this case, the court, actually the High Court and the Court of Appeal held that this is unconscionable because today you discuss on the issue including performance bond, and I asked you not to call. The next day you go and call it. That is unconscionable. The test is that the conduct itself is so unfair and it put the conscience of the reasonable person mind. All right. So this is unconscionable. Same project. Now I come back. When is okay to call on the performance bond? Same project, same but different contract. Today I call for a meeting. All right. December, 6 months or many months down the road, I call on the performance bond because there is a breach that justify me calling, even though I don't need to justify any breach because it is unconditional and on demand. But because the passage of time and because there are circumstances justifying me calling on the performance bond, same parties go to the court. The court says, in this case, same judge says that because of this, the meeting was called many months ago even though it's for the same project, but a different contract, because they are separate part of the project. In this case, you can call on the performance bond because there is no unconscionability. Right? So just the issue of performance bond, just to share with everyone, so that when it comes to actual real life practice, we can just bear that in mind. Right? That's all from us. Thank you. Just wondering, you guys will be here for quite many days, right? I saw the. Okay, all right. Anyone? So I suppose some of us from India. India, yeah.
Pakistan.
Pakistan, Pakistan. And front row, sorry. Where are you from? Uganda. Okay. You have a very nice handwriting. I saw. Thank you, everyone. Thanks.
Okay, take a 5 minutes break. I know it's already 5, but we still have 3 more persons to present their slides. So